Hi, good afternoon, class. Okay, my name is Ho here. So today I will present my seminar in this slide. So I will using a bio language. So kalau certain thing ada yang tak faham punya boleh tanya dalam bahasa Melayu ataupun English pun okay. So before we go further, I want to check the attendance. If I mention the name, you just say yes or no, okay? If no, that means that you're not here lah. No need to answer. Okay, So number one is Nurul Fatiha.
Yes, I'm here.
Okay, is Julia here?
Yes, I do.
Okay, is Crystal Jacob here?
Yes,
Crystal
I'm
Jacob,
here.
yes. Okay, is Maishara here?
Yes, I'm here.
Okay, is Siti Gurijato here?
Yes, I'm here.
Okay, very good. So we have a 5 person with us today. Okay, we go to the next slide in the introduction of the course. So today the course topic is essential of company secretarial practice for beginners. Before we go another further, so I'd like to introduce a little bit about our classroom rules. Be on time. So everybody is be on time right now. It's 3 o'clock. So you just want to act like what when you are at school, and then you sit in one spot during class. Keep yourself mute. If you have the handphone, then keep your handphone mute. Turn on your video. Always turn on your video, and then raise your hand to talk. If you if you want to talk, you just raise your hand and listen carefully. No eating during class. And especially this is the bulan puasa, so respect to everybody. No eating during class. So have fun and do your best. So just no need to be too stressed. So just listen and look at the slide. Okay. So before we go any other further, I'd like to have this ice-breaking activity. So let's warm up a little bit with this eye-breaking question. So everybody just tell me what is your name. Start with Nurul. What is your name? And then what is your daily job? And also what is your dream profession? You punya nama, you punya kerja setiap hari, and then apa you punya cita-cita. Okay, kita start with Nurul Fatihah.
Good evening, everyone. I am honored to have the opportunity to introduce myself. My name is Nurul Fatiha.
Okay, what you do daily? Yeah, what you do daily in your daily job?
As a secretary, my daily job is involve a variety of essential administrative tasks to ensure the smooth operation of the office. I manage correspondence by handling incoming and outgoing emails, phone calls, and mail, as well as drafting and sending communication on behalf of the management lah.
Okay, very good. And then the next is Julia.
Hello, hi everyone, and good afternoon. My name is Julia binti Hamzah. So my daily duties is the first one is answer phone call and respond to inquiries via telephone or emails. Other than is perform administrative tasks, including filing, copying, and printing. And the third one is preparing and distributing documents. And the fourth one is maintaining and updating records.
Oh, very good. Okay, so the next person will be Crystal.
Yes, good evening, everyone. My name is Crystal Dr. Jacob.
Okay.
My daily job scope would be filing, then to put files on the server staircase, to take the bags contain document from the audit table and also to arrange the files in the given room.
Okay, good. The next person will be Maishara.
Hello, hi. My name is Maisara binti Muhammad Yazid. And my daily job is depends apa yang client minta. Usually kita akan sediakan SSM, risk solution seperti open bank, close bank. Yang lain kita akan angkat call, reply email dan respond dengan apa yang client minta kepada kita. Itu je.
Okay, good.
Right, thank you.
Siti Hurijato.
Hi, my name is Siti Humaira. My daily job is filing and arrange sales, creditor, purchase. And sometimes I will key in at system UBS for some companies.
Okay, good. Very good. So it is very related to this topic. So what you are doing is very related to this topic. Okay, before we go further, let me introduce myself. Okay, I'm the founder for YB Management Services, a company in providing accounting, company secretary, taxation services since 2003 until current. Okay, then I'm also the founder for Easy Pro Business Academy Private PLT, a company providing a business academy, especially in accounting and team building activities since 2023 until current. So I have 20 more years of experience in accounting and business administration. And I'm also one of the HRDC certified trainer. So you're doing the this secretary job. Have you ever seen this page? Ada sesiapa yang pernah jumpa muka surat ini dah? Micro ID.
Benar.
Benar. Ada apa-apa isi kandungan dalam tempat ini? Dalam ini? Ada sesiapa yang boleh jawab? Mai boleh jawab. Okay. So tak apa. Micro ID is actually the short name for My Corporate Identity. It's a Malaysian government platform to develop by the Suruhanjaya Syarikat Malaysia, so-called SSM, or in English called the Companies Commission of Malaysia. It's designed for corporate information management. So what's inside Micro ID? Inside the Micro ID, we have the search and reservation of company name. The second one, we have the incorporation of reservation name. So the third one, we have an appointment, professional company secretary. The fourth, we have lodgement of constitution. Number 5, we have return of allotment of share. In short name, we call ROA. And then register of member, ROM. And also notification of change in register address. And notification of change in the register of director, managers, and secretary. So whatever changes in the company related to all these items, we will definitely come to this Micro ID to do the online submission and so on. Previously, we go to the counter and do the submission through the so-called this form, okay? So Micro ID, when we come to the name search, this is the first thing that we before we do the incorporation. The name search per each time is 50 ringgit. The extension of time can up to 180 days. So for, like example, the first 30 days is 50 ringgit. It's come to the end, close to the end of 30 days. If the client haven't make any decision, we can ask the client whether we want to do the extension of time or not. If the client want to do the extension, we can do another extension of 30 days and pay the $100, pay another 50 ringgit. So will become $100, then up to the 150 days. So the total will be 250. But normally the client will within 30 days or 60 days, we'll make the decision already. Okay, after we do the incorporation, the name search, when the SSM approve, so we will explain to the client, so what are the information needed, then everything we will key inside the system, and after that we will go to the incorporation of the company. So the first one, the application fee will be 1,000 ringgit. Then if we do have the constitution, we will need to pay the stamping fee online payment. But if we do not have the constitution at the time of incorporation, we no need to pay for this amount. And after that, we need to insert the object clause, the object code, then attach the authorization letter online if applicable. The appointment of the first secretary need to be within 30 days from the date of incorporation. But in January, the company secretary will be appointed at the first day when we do the incorporation. If we do the lodgement of the constitution, it also within 30 days from the date of special resolution. So by lodging the constitution, we need to use special resolution, yeah? So one member company, what are the advantages that using one member company? So easy to say, one member, we don't need to discuss any decision with any other body. So it's more complete control of the company, okay? We can make the business decision independently, and we have a full share of profit. We no need to deal with the shareholder and director. And also, it is not mandatory to hold the EGM board meeting, and also no retirement of director. Another, for this, a disadvantage for one member company, may be difficult to get loan because of one person. So if the bank gives the loan and then you are only the one person, anything happen to you, who will be going to pay back the loan? So it's a bit difficult to get a loan. If a sole member dies without a will, no authorized person to carry on business. And also the company operation at a complete standstill. So one person died, the only so-called is a director died during the business, the company will become complete standstill, cannot move on. So it is more advised to prepare a will. The company secretary to call meeting of next of kin to appoint a new director if the following happens to show director or members. If the director or members die, insanity, incapacitated. So the next of kin, okay, to request the following additional information of next of kin. The terms next of kin is not explicitly in the Company Act 2016. However, the intention of the law is to cover persons who are to make decision regarding the appointment of the director in place of the deceased sole director. It's not explicitly, it just means that it's not compulsory, but it's the intention for the law to cover persons who are to make decision if the sole director died. So it is same with the director and the members. We need to get the full name and the address of the next of kin, the IC number, the relationship with sole member, the telephone, mobile, fax number, email address. So this one is to get the information on each family member. The director of the company, any person occupying the position of director of a company by whatever name called, includes any person occupying the position of director of the corporation by whether name called, and includes a person in accordance with those with whose direction or instruction the majority of director of a corporation are accustomed to act, and an alternate or substitute director, so-called shadow director. Under the New Company Act 2016, one company shall have a minimum numbers of directors. There's only one. If under the old act, there must be at least two. A director shall be a natural person who is at least 18 years of age. A director shall ordinarily reside in Malaysia by having a principal place of residence in Malaysia and shall not include an alternate or substitute director. A member of that family means instead of shall include his spouse, parents, child, including adopted child and stepchild, brother, sister, and the spouse of his child, brother, and sister. A director is deemed to have control in the body corporate if he holds more than 20%, not 15, last time is 15, of issue shares or the voting power, or able to control the board of the body corporate. Disqualified of director, of course, if this director has been declared bankrupt by the power of registrar, then the director will be disqualified to act as a director. It may only act as director with leave of officer, receiver of court. Power of registrar to remove name of director who have been disqualified. Further that, convicted, whether within or outside of Malaysia, for any offences in connection with promotion or management of corporation, bribery, fraud, dishonesty, breach of duty of directors. May only act as director with leave of court after 5 years of sentences or release from jail. If disqualified by court due to his conduct which has resulted in two companies went into litigation in the last 5 years, means that got two companies went into litigation, it will be ordered by the court to disqualify to act as a director. It's contravention of his duty under the Act. Habitual contravention of the Act. And same also, may only act as director with leave of court after 5 years of sentence and release from jail. By court of officer receiver, unsound mind means gila, tak betul, or suffering from mental disorder. Okay, that's about the directors. Now we come into auditors. So everybody knows a Sdn Bhas shall appoint auditors. So the auditors shall report to the registrar on any breach of non-observance of any provision of the Act, circumstances regarding matters that have not been adequately dealt in the audit report. So the appointment of auditors of private company under the section 267(1), a private company shall appoint an auditor for each financial year of the company. Under the section 267(2), registrar is empowered to grant audit exemption for certain category of private company classified under SME, such as if the company is a dormant company, if the company is a zero revenue company, and then the third, the threshold qualified companies. A company qualified for audit exemption if it meets the following criteria: the revenue not exceeding 100,000 during the current financial year and the immediate past 2 financial year. The total assets in the current statement of financial position not exceeding 300,000 and in the immediate past 2 financial year. And number 3, not more than 5 employees at the end of the current financial year and in each of the immediate past 2 financial year. So if under these circumstances, the registrar is empowered to grant the audit exemption for the SME, for those company who meet the just now the mentioned criteria. Okay, appointment of auditors private company, under the two sections, section 267 bracket 3, the board of directors shall appoint at least 30 days before the end of the period for submission of its first financial statement to the registrar or to fill a casual vacation by auditor. Under the section 267 bracket 4, the member shall appoint an auditor by ordinary resolution. Is by ordinary resolution. So for subsequent financial year after submission of the first financial statement, number B, sorry, it's a mistake, and it's a B. If the board failed to appoint an auditor under subsection 3, the company in Malaysia deal with the appointment of auditors. Specifically, it states that if the company failed to appoint an auditor at its annual general meeting AGM, the registrar of the company has the authority to appoint an auditor for the company. This provision ensures the company comply with the requirement to have their financial statement audited, even if they fail to do so on their own. An auditor of the private company shall not make office until the previous auditor ceases to hold office unless he is the first auditor of the company. So number second, under the section 269 bracket 1 bracket B, small b, an auditor of private company shall cease to hold office 30 days after the circulation of the first of the financial statement to the member unless he is reappointed. So under the section 269 bracket 3, if the office of an auditor become vacant arising from section 269 bracket 1 and bracket B, and no auditor has been appointed by the member, then the immediate previous auditor shall be deemed reappointed unless the constitution require actual reappointment. Number second, member resolve no reappointment. Number third, deemed reappointment is prevented by member under the section 270. So the notice from 5% voting member can block reappointment under the section 270. Removal of auditors. Auditors can make written representation within 7 days. Copy to the circulated to every members. Copies need not be circulated and read out if, on application of company or other aggrieved person, the court is satisfied that the auditor is using this section to secure needless publicity or matter is defamatory or and some other grounds that the court think is reasonable. Replacement of auditors. A written resolution of private company to appoint auditor in place of outgoing auditor under the section 279. Companies send copy of proposed resolution of incoming and outgoing auditor. The outgoing auditors may make written representation, explain circumstances behind his resignation within 14 days of receiving the proposed resolution. So the outgoing auditor may request written representation to be circulated to all members. The court may prevent circulation and reading out the representation by reason of needless publicity. The meeting of members is under the special notice of the resolution will be required. So removal of auditor is under the special resolution. The proposed resolution to be sent to the person proposed to be the appointed next auditor. So remember, all others issue except removal of auditor and removal of director is under special resolution. Resignation of auditors. The auditors can deposit notice in writing of resignation at company register office. The resignation effective after 21 days under the section 281 bracket 2. Upon receipt of resignation notice, the company shall notify registrar within 7 days. Resigning auditors submit a copy of written representation of his statement of circumstances connected to his resignation to the registrar. So once received resignation letter from the auditor to a fixed company rubber stamp with date of on the letter, and submit a copy of the stamp letter of resignation to SSM within 7 days of acknowledgement. So the register office. So what is the register office? Under the section 46(3) need to be filed to reflect the change in the register office. And normally the register office will be the office of company secretary. And there's below are the sample of the resolution, change of register office sample. So you put that resolve, that with effect from the date hereof, the situation of the register office be changed from such address to another address. And then the company secretary of the company, Mary, or maybe who is the name of the company secretary, be and is hereby authorized to do all acts, deeds, matter, and things as may be necessary, and to sign and execute all necessary documents for and on behalf of the company for the purpose of giving effect to the above resolution, and to file and submit the necessary form and e-form with the registrar of the company. So from here, the sample of the resolution, did you all practice all the time in your company? Mine?
Yeah.
Sini ada tulis kak. Kalau dekat orang punya company, ia ada tulis sentence ini dah. That the company secretary of the company, Mary, or maybe who, might be and is hereby authorized to do all XD, blah, 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 until this necessary form and e-form with the registrar of company. Ada buat sentence ini dah.
Ada Mr. Ho.
Ada. Okay, ini sangat bagus. Sebab certain times, kalau ada come into the argument, director certain times dia ada mention, saya pernah cakap, tapi saya tak pernah authorize. Okay, saya pernah beritahu, saya nak buat ini, nak buat itu, tapi dia kata saya tak pernah bagi authorization. So kalau with this sentence means that the company of the director of the company is really giving the authority to the company secretary, who's called Mary, and then to authorize he or her to do this action, okay, on behalf of the company, and then to sign and execute all necessary document for the company and the purpose of giving effect of the above resolution, and to file and submit. So kalau ada perkataan dekat sini, ini adalah sangat jelas, ya, sangat jelas that director bagi instruction untuk buat change of register office, for example, and dia bagi instruction company secretary untuk membuat so, untuk to do so. Okay, so this is a very good practice. You don't have to practice all the time. So the situation of the financial or accounting record, and this is also almost the same. Okay, almost the same. The sample resolution that with effect from the date here of the finances or the accounting and related record of the company will be kept at what place? Okay, and then the company secretary of the company, who be and is hereby authorized to do all acts, deeds, matters, and things as may be necessary to sign, execute, okay, and then to do the file, submit the necessary form and e-form with the ROC, with the registrar of company. So under the financial statement
Mr. Ho?
circulation, under the section 258, private company within 6 months of its financial year end, if this is a public listed company, at least 21 days before the date of AGM. If the penalty not exceeding 50,000 and continuous offense 500 each day. Sangat mahal. So under the private company, within 30 days of financial statement and report circulated to its member, public company at least 30 days before the end of AGM, company may apply for extension of time. Each time of the extension of time need to pay a fee of 100 ringgit. And then if the penalty of this the penalty will not exceeding 50,000, and then the continuous offense will be 1,000 each day. Extension of time. So what is the condition for extension of time? Normally is accounts and records of document lost, destroyed by fire, flood, and other types of natural happen. Undergoing corporate restructuring, exercise merger and acquisition, and also under investigation and held by police, relevant authority, regulatory body. Normally, under these circumstances, SSM will approve. You cannot say, "Oh, I do not have time to update the account, so I need to apply for the extension of time." Normally, SSM will not entertain here. So, what is the annual return? The annual return contains the address of registered office, nature of business, address of place, business including branch, address of register of member if not at register office, the address which financial record are kept, if not kept at the register office, summary of shareholding, structure and debenture, amount of indebtedness. So all this kind of information will including in the annual return. And also the particular of directors, managers, secretary, and auditors. The service business address and expiry date of passport. List of members. If particulars unchanged from last year, company can submit a no change annual return. Particulars of beneficial owner. Registrar may strike off if company fail to lodge annual return for 3 or more consecutive years. And also the penalty for not doing so is 50,000 ringgit Malaysia, and continuous offense will be 1,000 each day. Okay, who is the company secretary? The company secretary is actually an officer of company. All companies compulsory to have at least one qualified company secretary. The position must not be left vacant for more than 1 month, means 30 days. Must be present as registered office in person or by his agent, and must give consent to act before the appointment. The company secretary cannot be bankrupt, cannot be convicted for offenses on management, fraud, dishonesty, or the insider trading will be disqualified. And the board have the power to determine the remuneration and does not have liens on book or other property of the company for unpaid bills. Company secretary duties, duties of care. Act in good faith with honesty and integrity. Ensure no conflict of interest. Highlight the issue of important before board make the decision. And maintaining the statutory record. And protect the interests of company and also the whistleblowing. Recording of minutes of meeting. Circulate financial statement. Lodgement of annual return with SSM, anniversary of date of incorporation, and maintaining the register office, publication of company name and company number outside of the office, maintaining the company register. Okay, the roles of the company secretary, details oriented, Kaizen, updates of current law, supporting chairman, the technically equipped, uphold ethical standard, the knowledge of corporate government, legal, financial, regulatory, and risk management knowledge, and confident to the board of director and CEO, the English proficiency, and edit the board of paper. It must be a networker, negotiator, administrator, and licensed officer with corporate regulator, drafting the chairman address, and prepare notice and proxy form, printing the document for general meeting, attending board, general meeting, etc. Professional advice, drafting minutes, convening board meeting, authentication, extract of resolution, updating all statutory records. And drafting, vetting agreement, legal matters, acting as chief administration officer, proficient in Company Act 1965, keeping and maintaining company register under the Company Act, lodgement of relevant form to CCM within prescribed period, advise chairman re-meeting procedure, administer share capital, insurance, NPL, SOCSO, IRB, but some of the company secretary is not doing that yet. It's only doing especially on the company issue. Those are EPL, SOCSO, IRB, normally a company will appoint administrative officers or whoever to do so. So for the company secretary, you have to take note, yeah. Do not be pressured by director or shortcut procedure. Even though if you're under the pressure by the director, you have to advise them correctly. You can resign if under the pressure. Act with integrity and honestly. Know everything must be done above the board. Keep record securely. Do not divulge company confidential information. Educate the board. Encourage board to attend the CPD, the continuous professional development. An educated board will help your job tremendously. Follow up with the directors and resolution. Ensure documents are all in order before executing the document with the regulator. The client's inquiry should be in writing to reduce misunderstanding. But now everybody are using WhatsApp, WeChat, okay? So incommunicado clients, send AR register letter to client on resignation. What mean incommunicado clients? Mean those clients are always trying to hide. They don't want to see you. They try to not to receive those summon letters. They not to receive the notice that asking the company secretary asking them to update their annual return because want to save money, all this kind of thing. So you have to send the AR register and take in refer clients. So resolution under the company, we have two resolution. One is so-called ordinary resolution, and one is so-called special resolution. What is ordinary resolution? The ordinary resolution is a simple majority. Simple majority means 51% of members entitled to vote, and may also be passed as special resolution under the section 291 bracket 4. If under the special resolution, there must be not less than 75% of members entitled to vote. The private company resolution, not a special resolution, unless it's stated as special resolution under the section 292 bracket 2. So like just now I mentioned, in the scenario, normally we have only two circumstances under the special resolution. Who can tell me? Anybody here? Removal of auditors, removal of,
Mr. Boleh you repeat tak soalan tadi?
sorry again,
Boleh
soalan-
you repeat soalan tadi?
oh, maybe the line over your side is not that strong, it's not clear for me to hear. So another circumstances is under special resolution is removal of directors. So the written resolution under the private company shall be proposed as written resolution by board or any member of the private company, except removal of director, removal of auditor. Okay. A written resolution not necessary, yeah. Or ordinary and special resolution can be passed as written resolution with the same threshold, simple majority and more than 75%. A written resolution can be proposed by a director or a member. Proposed by director is circulate to all members, must have statement on procedure signifying agreement or otherwise to the resolution. Then the date the proposed resolution shall lapse. Member written resolution. At least 5% of total voting right of the members may require the company to circulate resolution that may properly be moved as a written resolution. And then it's prohibited, inconsistent with written law or constitution, defamatory or frivolous vexation, if passed, would not be in the best interest of the company. Member resolution can be in hard copy or electronic form. State the resolution and provide accompanying statement, signed or authenticated by the member making the request. At least 2.5% instead of 5% or 50 instead of 100. Members with right to vote to demand, alter or add item into general meeting agenda. Written resolution circulation date shall be the date on which copies of the written resolution are circulated to members, or if copies are circulated to member on different day to the first of those days. So up to the moment, is there any problem? Anything that is not clear? Or you may be accumulated your question when come to the Q&A section, then you're only ask. Okay? So what is a share? Only a company limited by share can issue and allot share. A shares in a personal property that is transferable in the manner provided by the Company Act 2016 or the Constitution. A share carry with it certain right, voting, dividend, share of assets, and liability to pay call when due, while the company is a going concern and is winding up. Ownership of share does not vest down any property right to the assets of the company. Example, the shareholder owns the share but does not own the property that is registered in the name of the company name. Subject to the Constitution, the share may be issued in the different classes, be redeemable, confer preference shares right to distribution of capital or income, confer special, limited or conditional voting right, or not confer voting right. But that one we will not go further, yeah? The type of share. The type of share can be without the Constitution. If let's say without the Constitution, can only issue the ordinary share. With constitution, can issue different classes of shares. Referred to as equity capital of the company, and holders are usually entitled to attend, to speak, to vote at general meeting, to receive equal share of dividend declared by directors, to receive the equal share in the distribution of surplus assets in a winding up. The right to dividend may be negated, altered, or added to by the Constitution or in accordance with the terms of issue under the Section 71(2), and may be issued in different classes with different rights if allowed in the Constitution. The shares are regarded as a property that can be owned by a person and has a title that is transferable from one person to another. The ownership of share in the company therefore entitles several rights and entitles the owner to take part in the affair of a company that is governed by the Constitution, and is conferred upon its shareholder rights and liability when the company is going concern and upon its winding up. Shares in the movable property, they are transferable in the manner provided by the Constitution. Classes of share. Ordinary share. This is the very common class of share that we see in the number. The ordinary share are also called equity share. It is the risk capital of the company. The ordinary shareholders are entitled to their dividend after preference shareholders. It's a risk capital, and ordinary shareholders have full right to vote by the Constitution, and they control the company. If you have more than 51%, you are the major, simple major shareholder. In the event of litigation, ordinary shares rank after all other liability of the company. Preference, we have the preference shares, and then we have convertible preference shares, and we have non-voting shares, and we have the employee shares. Under the preference shares, a holder of preference shares has no right to voting unless allowed in the Constitution. No right to dividend other than that stated in the Constitution. No right to receive amount more than the issue price of the preference share on redemption unless allowed in the Constitution. The preference share also no right to participate in surplus asset on winding up other than the repayment of the capital invested unless allowed in the Constitution. And also the preference right in the payment of dividend in priority to dividend to ordinary shareholders and repayment of capital in the winding up. So these are the preference shares. Participating carry a right not only to receive dividend at a specific rate, that also to receive further dividend if any surplus profit remain after a dividend has been paid to ordinary shareholder. To carry a right not only to receive dividend at a specific rate, but also to receive further dividend if any surplus profit remain after a dividend has been paid to the ordinary shareholder. Non-participating only carry out the right to a fixed rate of preference dividend without any right to get additional dividend. We have accumulative and non-cumulative under the preference share. Okay, the allotment of share. Private company can allot further shares, but it is limited to 50 shareholders. The private company shall not offer to the public any shares of debentures of the company. Allot shares of debentures with a view to offer such security to the public. Shall not invite public to deposit money with the company, whether with or without the interest. Company can only allot further shares if a statement in lieu of prospectus has been lodged with SSM and every director has paid for the share which they agree to take up. And then the private company shall not allot shares or debenture unless it has issued a prospectus or a statement in lieu of prospectus has been lodged with the SSM at least 3 days before the first allotment of either shares or debenture under the Section 188 under the Company Act 2016. The default, let's say it's a default in the case of the company to a fine not exceeding 5 million. In the case of an officer, imprisonment not exceeding 5 years, or to a fine not exceeding 1 million, or to both. Allotment of share. Then what is the effect for the allotment of share? To become a member, to bound by its constitution and liable to pay any balance of the share allotted to him or her. Allotment of share by cash means that allottee pay for share in cash, bank draft or check. If the allotment of share for consideration other than cash, the share of the company are issued to somebody for something which is not in cash. Means maybe in asset, like vehicles, like heavy machinery, all these kind of things. So the allotment of share for consideration other than cash. Example, to vendor against the purchase of asset. Okay, to sell the purchase of asset. Purchase of entire business of the company for services provided, intellectual property. Okay, we have 2 stages of allotment of share. One is issue of share. One is allottee complete application form together with the remittance. The issue price. The issue price of the share is set based on willing seller, willing buyer. It is a commercial bargain between the company and the shareholder or investor. The director have to take note that they have a fiduciary duty to set the price in good faith. Unless otherwise provided in the Constitution, a company may alter its share capital by passing an ordinary resolution to consolidate and divide all or any of its share capital, the proportion between the amount paid and the amount, if any, unpaid, on each subdivided share shall be the same as it was in the case of the share from which the subdivided share is derived. Alteration of share capital, unless otherwise provided in the Constitution, a company may alter its share capitals by passing an ordinary resolution to subdivide its share or any of the shares, whatever is in the subdivision, the proportion between the amount paid and the amount, if any, unpaid of each subdivided share shall be the same as it was in the case of share derived, the share from which the subdivided share is derived. The director have the power to allot the share. The director have the power to issue share by way of under the Section 75 bracket 2, right issue, bonus issue, consideration share for acquisition of share or asset. But the company and the members have been notified in writing and via advertisement of the intention of at least the days before the issue set under the Section 75 bracket 2. The share issuance by the director, the allotment of share under the offer to shareholder in proportion to shareholding, allotment of share on bonus issue of share to shareholders in proportion of shareholding, the allotment of share to the promoter, and also where the share are issued as consideration of acquisition of shares or the asset of the company. lodgement of return of allotment of share within 14 days, update the allotment of share within 14 days in register of member. Okay, just now we are talking about the share. Now we are talking about the common seal. So what is the common seal? The common seal is the signature of the company and usually used on agreement, share certificate, debentures, contract, etc. The company's name and company's number appear legally on the common seal, must use in accordance with the resolution of the Board of Directors, authorizing the affixing of the company seal in the presence of two directors or a director and a secretary, or as stated in the Constitution. So these are the look-like of common seal. You have the company name, you have the company number. The share certificate under the Section 98. Where a share certificate has been issued, a transfer of share to which is related shall not be registered under the company unless the form of transfer is accompanied with the share certificate relating to the share or by evidence as to its loss or destruction and, if required, an amount as set out under Section 104. Where share to which share certificate relates are to be transferred and the share certificate is sent to the company to enable the registration of the transfer, the share certificate shall be cancelled. And default by doing this, the company and every officer who contravene this section commit an offence and shall, on conviction, be liable to a fine not exceeding 10,000 ringgit. The issuance of shares certificate. The company shall not be required to issue share certificate. The shareholder have to apply for share certificate within 60 days of receipt of application to send share certificate to shareholder. If transfer of share, to return share certificate for cancellation. Once cancelled, no further share certificate will be issued, except at the request of the transferee. But in normal practice, when we issue a share to a shareholder, we will issue them a share certificate for recording, for his or her recording, and also for company secretary recording purpose. The delivery of share certificate. Failure to deliver share certificate under the Section 98, a person may serve notice to the company, and the company must then deliver to the person within 14 days from the service of such notice. Failure to do so, the penalty will be 10,000 ringgit. What does share certificate contain? It must contain the following: the serial number, the company name, the name of register holder, and description of the share or stock. And also the number of share of amount of stock, date of certificate, address of register office, and also must fix a common seal. Lost share certificate. The member shall be requested to make a further thorough and careful search for the certificate. Then inform the company whether or not the certificate has been found. The replacement loss of certificate. A statutory declaration that certified has been lost or destroyed and not pledged, sold or disposed, and undertaking, if found, to return to the company. So a statutory declaration must be made. The letter of indemnity. A director resolution to approve replacement the certificate. Update register of member and issue new share certificate within 60 days of application. And some other common practice, they need to lodge a police report and get the police report as an evidence, and then also do the statutory declaration, letter of indemnity, then only pass to the director, and then the director will only consider and come up with a resolution to approve the replacement of certificate. Transfer of share. The shareholder may transfer all of any of his share or debentures in the company by duly executed and stamped instrument of transfer and shall lodge the transfer with the company. The company shall enter or cause to be entered in the name of the transferee in the register or member as shareholder within 30 days from the receipt of the instrument of transfer. So these are the lookalikes of the transfer form under the Section 105 New Company Act 2016. Transfer of share require the execution and deliver the proper instrument of transfer form 32A. Now it's called Section 103. A private company contains pre-exempt clause. Prima facie transferable refusal must be effected by directors. The resolution refusal does not affect the contract between the transferor and the transferee. The refusal must be notified within 1 month of lodgement. The registration of transfer and request of transfer. And the procedure is applicable to non-listed and private company. Under the Section 105, to be completed and signed by both transferor and transferee and witness. Need to be stamped before registering. Transfer must be approved by the director. They have the right to refuse the registration of the transfer. Update the register of member. The registration of transfer or refusal of registration, unless Act or Constitution permit the directors to refuse or delay registration for the reasons stated. Director pass a resolution to refuse or delay the registration of the transfer within 30 days from the receipt of the instrument of transfer, and the resolution set out in the full the reason for refusing or delaying the registration. The reasons to be sent to the transferor and the transferee within 7 days of the resolution being passed. The offense by doing this, the penalty will be 50,000 ringgit Malaysia, and the continuous offense there will be 500 ringgit for each day. The refusal can be shareholder failed to pay the company an amount due in respect of those shares, whether by way of consideration for the issue of the share in respect of the sum payable by the shareholder in accordance with the Constitution, means that the shareholder didn't pay the money. The directors may decline to register the transfer of share over which the company has a lien. In case of the death of a member, the person recognized as having any title to his interest in the shares or debenture shall be, where the deceased was a sole holder, the legal personal representative, and where the deceased has a joint holder, the survivor. Transmission of share happen upon the occurrence of an involuntary act, such as death of the shareholder, the becoming insane or an unsound mind, a bankruptcy of an individual, litigation of a corporate body. And also the written application for transmission regarded as proper instrument of transfer on death, share vested on administrator or the executor, bankruptcy shares vested in official assignee, on lunacy, shares vested on court-appointed receiver, on litigation, the share vested on litigator. The difference between the transfer of share and the transmission of share. The transfer of share is a legal ownership of the share changed by a voluntary and active act on the former owner, sales of share, or as a gift. And the transmission of share is the change of the ownership not by agreement or voluntary. It's by operation by law, death, bankruptcy, unsound mind, the statutory record. The company secretary, just now we already mentioned the duty of the secretary is do the recording, the statutory recording, to maintain the company's statutory and non-statutory book. Documentation of the company are kept in order, time frame to lodge the form and documents, and filing fee and late lodgement fee to pay the filing fee and late lodgement fee, circular issued by CCM from time to time, complying with Company Act 2016, how to lodge the form. So after when we do the resolution or certain issue, we have to need to adherence, or we have to need to follow the time frame to lodge the form and document. Otherwise, it will cause the delay in submission and will cause the penalty. Requirement to keep the record. The company must keep records comprising of all resolution parts, the minutes of meeting. The record must be kept for at least 7 years. Statutory register must be open for inspection of RM by any member without charge. Other person, 10 ringgit for each 100 word, and copy to be sent within 21 days. Record as evidence of proceeding. Show the meeting was duly held and convinced. All proceeding at the meeting has taken place, and all appointments at the meeting are valid. And also the resolution has been properly executed before action. So records are very important when it comes to become as evidence for proceedings. Register office. Each company shall have a register office within the Malaysia. The company is a separate legal person. The register office is where all communication and notices may be addressed and document can be served. And it shall be open and accessible to all the public during ordinary business hour. And then to notify the registrar of any changes within 14 days if the register office has been changed. Display the name of the company prominently at the register office. Must inform SSM where there is any change of register office. Due to many new clients and clients leaving may be costly to change the nameplate. So if very costly to change the nameplate, then using A4 paper. The document kept at the register office, such as the notice of registration, the constitution, register book, records, and documents under the Company Act 2016, the financial statement, minutes of meeting, resolution of board, shareholders and committee, accounting records, director's service contract. So all these kind of documents have to be kept at the register office. Director's service contract, certificate given under Company Act 2016 and 2016, 1965 and 2016. A copy of written communication to member and charge document. Failing by doing so, the penalty will be 10,000 ringgit, and the CO continuous offense, there will be a 500 each day. So members, who are the members? The member is the name entered in the RM, register of member, the company and LLP. The sole proprietorship and partnership, not body corporate or legal entity. joint holder, club, association, or society are unincorporated bodies can be member if their constitution allow. The ROM shall be prima facie evidence of any matters inserted in the register of required or authorized by this act. Every company shall keep a register of its member and update its record. The shareholding particular like number of share, types, share certificate number, date of allotment, contain personal particular like name, IC, passport number, expiry date of passport for foreigner, date of birth, address, citizenship, date as member, date cease as member, and then the time frame and update register within 14 days. Not applicable to listed company and prima facie evidence of members. Failing to do so, the penalty will be 20,000 ringgit Malaysia, and the continuous offense will be 500 each day. Under the micro ID to do the following, the RM is under the micro ID. Any changes in the particular of shareholders must be submitted online within 14 days. And this is not applicable to the public listed company. Receive from the company the beneficial ownership of the shares to be recorded in the ROM. The importance of ROM. Issue and payout shares are recorded. Changes in share capital. Resolution are passed for changes to share capital. Allotment of shares supported by resolution and payment. The transfer of share recorded in ROM and SSM2. The closure of ROM. The company may close the ROM by giving at least 14 days notice to SSM. The ROM can be closed for not more than 30 days in aggregated in any calendar. Index of member. Company with not more than 50 members. The shareholding particular like number of share, type, share certificate number, date of allotment, time frame to update the register within 14 days. And it is also not applicable to listed company. This has been mentioned in front. Register of director shareholding. A company shall keep a register of director shareholding at the register office or other place and notify to SSM. Within 3 days of receiving a notice of any changes in interest from the director, the company shall enter into the register the particular of the notice. The particular to be recorded, such as number of share held, the debenture of interest made available to a director, the right or the option acquired, the contract to which the director is a party. Inspection of the register. The member, if you are the member, it is free. If other than members, it's a ringgit Malaysia, 20 ringgit or less. For all public companies other than CLBG must maintain this register. Person who has interest in 5% or more voting shares must notify the company of his interest under the section 136. The particular that needs to be included name of all the substantial shareholder, their nationality, address, amount held under the section 137, the notification, date and particulars information of any changes. This ceased to be a substantial shareholder. Register of option holder. Where a company grants option to a person to take up an issue share in the company, it is required to keep a register of option holder. The register of options is to be kept at the register office or such other place as notified to SSM. Register of option of holder, the company shall within 14 days of granting an option enter into the register of following particulars: the name, address, and the IC number, passport number for non-Malaysian, and the nationality of the holder of option, the day on which the option was granted, the number and description of the share in respect of which the option was granted, the period or the time of option may be exercised, the options period, the option price, such as particular as may be prescribed, register of charges. Every company must keep a register of charges together with the instrument creating a registrable charge. This register must be kept even though there is no charge created. Particulars of the register, a short description of the charged property, the amount of charge, the name of the chargee. Companies shall keep a copy of the instrument creating any charge at the register office, and also the company must keep a register of charge and enter all charges created that affects the company property. It must be authorized by resolution. To get the certificate of registration of charge, to get certificate of discharge of charge, discharge, to request confirmation from bank. Minutes book. Contain minutes of all proceeding of general meetings, board meetings, and also the managers meeting. The minutes to be signed by chairman. And minutes book must be kept at the register office. The minutes book can be inspected by members at no charge. Okay. The right attached to share. One share, one vote. An equal share on dividend. An equal share in distribution of surplus assets of company and winding up. AGM is mandatory for public company. And private company are no longer required to convene AGM. The decision making of private company will be by written resolution except in cases of removal of director and auditor. AGM, the private company, the circulation of accounts within 6 months of financial year end under the section 258 bracket 1 and bracket A, and lodged with SSM within 30 days from the financial statement and reports are circulated to its member. The appointment of auditor. The first auditor are appointed by the director, as mentioned just now, and subsequent by members' ordinary resolution. So, retirement of members, the retirement of directors, up to members to decide by way of written resolution. Allotment of annual return to lodge with SSM and annual return for each calendar not later than 30 days from the days of anniversary to the date of incorporation. The auditor to fill vacancy upon application by member. Protection for shareholder. The member shareholding at least 10% of payout capital can request a director to hold a physical meeting. More than 12 months since last meeting convenes under this section, and the proposed and resolution not vexation of frivolous. And this is for the public listed company. So for the private company, the meeting of members, the circulation of the notice must be at least 14 days. And for the public company, the AGM must be at least 21 days. Other than AGM, at least 14 days. Short notice, we can have a short notice for the private company, but a majority, 90% members must be approved. And for the public listed company, 95% of member must be approved. The notice of place of members is a place, a date of time of meeting, general nature of the business of the meeting, may include text of any proposed resolution. The notice can be in hard copy, can be in electronic form, and also can be partly in hard copy and partly in electronic form. Appointment of proxy. Dispensation of qualification of proxy, may appoint another person as proxy. Appointment of more than one proxy shall only be entitled to vote on a poll to specify the proportion of holding to be represented by each proxy, otherwise not valid. The corporate representative, a certificate of authorization by the corporate shall be prima facie evidence of the appointment or the revocation of the appointment, as the case may be, of a representative under this section. The meeting, the venue requirement. If two venue, the chairman shall be at the main venue, which must be in Malaysia. The quorum. The quorum, single member company, quorum can be one. Otherwise, two member. Mostly we have these four types of meeting: AGM, members meeting, director meetings, class type of share, class of share meeting. The board of director meetings, no rules on period of notice, mode of notice not defined, the agenda and board paper frequency depends. The quorum, when majority of votes and minutes kept. Conducting a board meeting, voting by show of hand. No provision in Company Act 2016 for voting by poll. Decision is made by a simple majority. If there is an equality of votes, the chairman have a casting vote unless the Constitution stated otherwise. The valid notice must have authorized, have the notice, date and time of meeting, place of meeting, the period, the agenda, ordinary agenda or the special agenda, and also the proxy form. End of the meeting. The meeting has unfinished item of business. It can decide by the next adjourned meeting. If urgent more than 30 days, the fresh notice must be given. The termination for not unfinished businesses can decide the next meeting and agenda. Vote of thanks to the chair. Postponement of meeting. Postponement means that the commencement of a meeting is itself deferred. Cancellation of meeting. A planned event will not take place. Right attached to share. One share, one vote. An equal share on dividend. Equal share in distribution of surplus asset of company winding up. Member right. Member right. I think this one we already mentioned just now. Okay, dividend. Dividend under the section 131 to section 133. A company may only make a distribution of profit if company is solvent immediately after the distribution. Solvent means that can pay debts, can pay debts failing due within 12 months of after the dividend distribution. So only cash flow solvency test require and no requirement for director to sign. If before payment is made, the company ceases to be solvent, the director must take necessary steps to prevent the payment. The company has the power to recover dividend impromptu distributed from shareholder and from the dividend and managers who are authorized to payment. And general requirement for forms lodged with the registrar. Paper medium, weight, size A4, prospectus, not less than international sheet, size A5 and not more than A4, clearly printed, typewritten, 10 point, the margin of not less than 2.5 cm on the left hand side and not less than 1.5 cm on the right hand side. No carbon copy. So all this kind of thing, for those who have done daily, they will know. This is the standard, yeah? Standard general requirement for form lodged with the registrar. More than 2 sheets to be bound together securely. More than 20 sheets to be bound inside a durable and flexible cover. A punch to hole endorsed on the upper left hand corner of every page with the company numbers. The document shall have on the upper left hand corner the company number allocated by the registrar to the corporation to which the document relates, the name of the corporation to which the document relates, title of the document, the name, address, telephone number of the solicitor or other person by or and whose behalf the document is lodged. Normally is the company secretary. So the general requirement for form laws endorse the name, address, telephone number, any person by or on whose behalf the company is lodged, the end of each document. The fee must be paid at the time of lodgement where applicable. Otherwise, the registrar is precluded from doing that extra things until the fee has been paid. Money comes first, yeah? If the document fails to comply with the requirement, the document will not be accepted for pre-lodgement. Okay, time to lodge form or document. Normally is where a form or document is required by the Act to be lodged with the ROC by the period of time which is the document is to be lodged is not prescribed. The document shall be lodged within 30 days. Mode of payment. Personal check is not allowed. Company check also not allowed. Only check issued by secretarial, management company, audit company, legal firm allowed. Credit card and online payment. Lodgement fee of late. Lodgement fee is prescribed fee. Late lodgement fee depends on how late the lodgement of form and whether it is private or public company. Common area. The form undated, no signature, etc. Incorrect or inconsistent information based on previous record of company. The lodgement of document earlier than the date of event of date of document. Fear of being late in submission. Kiasu. So the common error. The forms and the documents are not in order, incomplete information. Withdraw statutory forms already registered, court order required. Application to ratify, register with amended document. SSM approved, then register, ratify. Application to ratify, register with amended document. SSM reject, apply to court, lodge court order with SSM, then register, ratify. So in summary, introduction to the role and responsibility of a company secretary is understanding key aspect of corporate secretarial practice for beginner, overview of maintaining corporate records and ensuring the compliance with legal requirement, the key activities such as presentation and filing of statutory documents, practical example and insight for effective secretary operation. So we come to the end of our slide. So shall we have a 10 minutes rest and then we come back to our Q&A. Hi, welcome back to the Q&A section. Is there any problem or any question from the floor?
Sorry, Mr. Ho, I have a quick question related to what you just mentioned before. May I ask, if there is only one director and shareholder, is it mandatory to have a next of kin?
Or next of kin? Let me see. So, okay, you look at this slide, tengok balik this slide, dekat page 17. The company secretary to call meeting of next of kin to appoint a new director. If the following happens to sole member, kalau dia sole member or sole director death, insanity, lepas tu incapacity. Lepas tu we look at this page, the one member's company practice to request the following additional information of next of kin. The terms of next of kin is not explicitly in the CA 2016. It's not necessary. However, the intention of the law is to cover persons who are to make decision regarding the appointment of a director in place of a deceased sole director. You understand? Faham tak?
Yes, thank you, Mr. Ho.
Okay, alright. Ada apa soalan lagi?
Sorry, Mr. Ho.
Yeah.
Okay, so how can we confirm that the director shall ordinarily reside in Malaysia?
How can we confirm the director
Shall
shall ordinarily reside in Malaysia? Okay, let me see. Okay, you see here, under the director of the company, a director shall ordinarily reside in Malaysia by having principal place of resident in Malaysia and shall not include an alternate and substitute director. So it must not be a Malaysian. It can be an overseas foreigner, but he or she must have a principal place of resident in Malaysia so that anything happen, the government, the SSM can contact him. And then for this principal place in resident in Malaysia means that this a foreigner, he or she must have a tenancy agreement. So it means that this is a proper place of resident in Malaysia. Then it can be qualified to become a director of the company already. Okay.
Okay, thank you, Mr. Ho.
Okay. Next question.
Mr. Ho, I also have question. What time allow for circulation of financial statements and report?
Time allowed for circulation of financial statement. Let me see. So can you see that? The financial statement circulation for the private company, it must be within 6 months of his financial year end. Within 6 months.
Okay, Mr. Ho, thank you.
And you can see here the penalty. If not default of doing this, the penalty will be not exceeding 50,000. So must be within 6 months of his financial year end. Okay.
Mr.
Any
Ho,
else?
I would also like to ask a question.
Yeah.
What duties of a company secretary?
The duty of company secretary. Okay. All of you are doing this company secretary job, right? So anybody can tell me, just come out from your mind. So what are the duty of the company secretary? Mike, can you tell me one? The answer is in front of you. Duty of care.
Duty of care.
Act in good faith, honestly, ensure no conflict of interest, protect interests of company, maintaining a statutory record, whistleblowing. What is whistleblowing? Whistleblowing means that if you feel that this company is doing illegal business activity, so you have to inform maybe police, income tax, custom, and all the related authority department if the company is doing an illegal business activity. So this is so-called whistleblowing. Like they are doing anti-money, anti-laundering money. So you have to inform the related department also that this company may have this business transaction. Understand?
Got it. Thank you, Mr.
So a part of this, there are many more. There are many more of this duty of the company secretary. This is page 45. See, page 46. See, recording the minutes of meeting, circulate the financial statement, lodgement of annual return with SSM, which is calculated anniversary of the date of incorporation, maintaining the register office, publication of the company name and company numbers of the clients in front of your business office, and maintaining a company register. I think this is also the rules of the company secretary, knowledge of corporate governance, legal, financial, regulatory, and risk management knowledge, confident to the board of and CEO, support the chairman, technically equipped, all these kind of things. It's the duty and the roles of the company secretary. And maybe it's many more that you can maybe find from the Company Acts and also from the Googles. Is that okay?
Yes, thank you, Mr. Ho.
All right.
Okay, Mr. Ho, I would like to ask you about what are different between ordinary shares and preference shares.
Ordinary share and preference share.
Yeah.
All right. See the ordinary share. The ordinary share are also called equity share. It is the risk capital of the company. The ordinary shareholder are entitled to their dividend after the preference shareholder. And ordinary shares have full right to vote by the constitution and they control the company. That is the how to say, the difference between the ordinary share and the preference share. The ordinary share have the full right to vote by the constitution. And then the preference share is only to receive the dividend because they are pay out the more capitals, they pay out more capitals, and then they do not have the right to vote. They just see if the investment or this business is good, then they come up with their money, then they only receive the preference shares. They don't have the right to vote, so everything is under the control of the company. Is that okay?
Okay, I understand. Thank you.
Any
Mr.
more else?
Yes. Is it mandatory for every company to have common seal?
Common seal. The common seal is the signature of the company and usually used on the agreement, share certificate, debentures, contract, etc. If you are entered to this business transaction, then you must have the common seal. If you don't enter into this common seal, if you don't enter to this business transaction, you may not order the common seal until you come into it.
All right. Thank you, Mr. Ho.
Okay. So any more else?
Mr. Ho,
Yeah.
would you be able to clarify for me what should member do if lost share certificate?
Loss of share certificate. Okay. In common sense, if you think that you are lost, this member have lost the share certificate. In common practice, they should report to the police to get the police report. Okay, to get the police report and then come to the company and then report to the tell the company secretary. The company secretary will inform the directors. The directors later on will come up with the resolution and mention that which share certificate has lost and decided whether to reissue the share certificate. So 97, 98. Replacement, the loss of share certificate under the section 104. The statutory declaration. The statutory declaration that certificate has been lost or destroyed. So not pledged, sold or disposed an undertaking if found to return to the company. And then they also need to issue a letter of indemnity. Then the director's resolution to approve the replacement of certificate. Update the registrar of member and issue a new certificate within 60 days of application. Report police, doing the statutory declaration, issue a letter of indemnity, then the director resolution will come up, see whether to approve or reject the replacement of certificate. If approved, then the company secretary have to update the registrar of member and issue a new share certificate within 60 days of his application. Understand? Okay, since you all are in this industry for some months or some maybe have entered in the year, can I have some question for you all? If let's say you have a new company and you have a new client come into your company and saying that they want to incorporate a company so-called in Sendang Berhad. So what is the normal procedure that you're doing?
Get the information first. Okay.
Get the information. What kind of information?
Like their IC address, and also if they has business address, email, number phone, and their full name.
Okay. Do
Okay.
you ask the client what are they doing? Do you ask the client what are they doing?
Ada duit?
Ah. Apa klien buat? Dia bikin nature of business.
Ya. Nature business apa company diorang buat.
Okay. So apa lagi selepas itu?
Kita boleh proceed untuk buat name search untuk nama company diorang.
Okay. So we do the application of name search. How much we have to pay for the name search?
Bayar untuk name search?
Yeah.
RM50 Malaysia.
50 ringgit Malaysia. If come to the expired of 30 days, so can the client ask for extension?
Boleh, tapi diorang ada kena tambah bayaran lagi.
Kena tambah bayaran.
Ya, betul.
Berapa?
Ya,
RM50.
Okay, RM50.
RM50. So after the name search has been approved, so what shall we do?
Nama dah approve, then kita boleh proceed untuk prepare dokumen untuk dorang sign semua. Dan dokumen prepare incorp company dengan dokumen untuk beneficial owner.
Okay. So kalau director cuma satu orang,
Okay, kalau director cuma satu orang, kita akan tanya dorang untuk dorang punya next of kin. Kalau director lebih kepada dorang, so next of kin tu kita tak payah tanya dah.
kalau director beritahu you dia cuma seorang saja, dia tak ada family members, tak ada kawan, tak ada apa, so macam mana lah?
Yang itu pun saya rasa dia still kena ada next of kin kan, sebab dia seorang.
Boleh letak nama Mai?
Boleh?
Boleh ya, betul. Next of kin dia tak semestinya ialah spouse, tak semesti ialah brother, sister. Dia cuma rasa kalau dia relatif dengan dia, kalau dia kawan dengan dia pun boleh. Kawan dengan dia pun boleh. As long as orang itu dia sudi lah, dia sudi menjadi next of kin lah. Okay, so lepas all the information gather and then we prepare the document, let the client signs. Then after that, what should we do?
Bila kita dah dapat director semua dah sign, kita kena submit incorp company dekat Micro ID.
Betul.
Ya, betul.
So cuma Mai seorang saja yang selalu buat dekat micro ID ke? Yang partisipan yang lain pernah masuk micro ID ke? Atul, Julia, Crystal pernah masuk? Ya, Julia pernah masuk tak? Itu micro ID. Sistem micro ID.
Pernah.
Oh, so apa you buat dekat micro ID? Apa transaction you buat?
Usually kalau micro ID yang I pernah buat, appoint director.
Appoint director.
And
So
then
director itu ialah Malaysian ke foreigner?
Malaysia.
Malaysian.
So far, I buat yang Malaysia. Foreigner and tak pernah buat lagi.
Oh, tak pernah buat lagi. Nanti tanya dengan Mai lah. Kalau itu director dia bila umur 16 boleh jadi director ke?
16 tak boleh.
Tak boleh ya? Betul ke tak boleh?
Tak.
Tak boleh ya? Wah, pandai lah. So sekurang-kurangnya ialah berapa?
Sekurang-kurangnya umur dia
Nombor yang Chinese suka bingung lah biasa. Ada 8 bingung.
18.
Wah, pandai lah.
18 and above.
Oh, okay. So sebelum director being appointed as director adakah apakah itu apa prosedur yang sepatutnya kita boleh ambil lebih lanjut?
Sorry?
Sebelum itu director di appointed as a director of the company, any others procedures, any others action that we shall do? Macam you kena check dia ada bankrupt ke apa ke? Ada pernah buat macam tu? Ada
First thing, sebelum kita nak appoint dia as a director, kita kena check insolvency dia. Adakah dia bankrupt ataupun tidak. So,
Kalau kita tak buat tapi director ada buat statutory declaration kata dia tak ada bankrupt, tak ada apa, boleh tak?
still kita kena check insolvency tu.
Oh, still kena check lah. So you ada charge customer?
Insolvency, ada 5% RN RM10.
Oh, RM10. So I think this is the best practice lah. We do at our part, and then we have to ensure this director is actually free from bankruptcy, free from any victims that they have offences within Malaysia and outside of the Malaysia. So there will be no problem lah. There will be no problem for the directors, for those person who being appointed is clean. Kalau tidak nanti lepas jadi director baru tahu dia bankrupt punya, baru tahu dia pernah ataupun masih dalam ada case yang kata dia ialah salah, ada fraud, ada dishonesty, nanti banyak kerja lah. Nanti of course dia kena resign, dan dia kena ini itu. Kalau orang ini sudah jadi so-called bank guarantor, so-called any important position in the company, then banyak prosedur yang kita kena buat lah kemudian. So it's a good practice. It's a good practice. So atau apa yang orang buat biasa? Dia ada pendapat masuk dalam micro ID kah?
Untuk micro ID tu komputer yang ada internet lah boleh buat.
Oh, ada internet baru boleh buat. Pernah buat itu tukar alamat?
Saya ada sebenarnya.
Oh. So setiap kali kalau kata when come to annual return, buat submission to annual return, ada apa-apa isu yang selalu berlaku?
Annual return Mr. Ho.
Annual return.
Annual return biasanya yang part yang susah kita kena minta loan daripada klien. Jika kalau dapat klien tu yang okey, senang bagi, senanglah. Kalau kadang-kadang kita minta klien tu loan statement, kadang-kadang seminggu lebih, sebulan baru kita dapat balik.
Ayo, ini macam non-corporate punya kah? Itu kalau loan statement itu ialah under mana satu part dekat annual return? Indebtedness ke, charges ke?
Indebtedness and charge.
Indebtedness dengan charges ya. So apa penting kenapa penting sangat kita mesti mau declare client punya indebtedness dengan dia punya charges dekat annual return? Apa yang orang rasa? Public boleh beli information dekat SSM dah. Kalau kata customer punya dia punya dia punya satu kawan dia mau tahu company ini dia business activity macam mana, ataupun for example like a financial institution, if they come to the bank A, the bank A want to know whether this client they have many loans or many others liability from this company, so they can check with the SSM to buy the company information, right? Right, betul tak? Dia boleh check dekat SSM dan beri dia punya annual return sampai tahun ataupun sampai tarikh annual return di prepare in the last punya submission, berapakah hutang, berapakah indebtedness yang mereka ada. So bank pun akan buat consideration, see whether dia orang mau offer new loan kepada customer ini. Kalau dia hutang terlalu banyak dan mereka rasa mereka punya turnover terlalu kurang, profit terlalu kurang, you rasa bank itu akan beri offer dia loan lagi tak?
Tak.
Kan? Mesti. So inilah information yang selalu kita kena update dengan klien. Kalau dia tak ada, minta customer, minta dengan buyer dan minta dengan bank. Mesti ada punya. Dia tak akan cakap tak ada. Dan dari mana kita tahu sama ada customer ini dia ada loan? Faham maksud saya? Dari mana you tahu customer ini ada loan? Biasa.
Biasanya kita akan minta daripada klien.
Tapi klien kata, I sudah lupa. Macam mana? So, you tengok sebelum klien enter into any purchase or any financial facility ya, biasa kita buat apa? We always prepare the resolution for the client to sign and then send to the financial institution, correct or not? So from your system, you already know they have the facility, they have the loan with whoever, with the financial institution or the credit company. So from there, if you have always updated all the resolution prepared by you, and then you follow up with the client when they sign back, means that they already taken up the loan or whatever facility. So from there, you already know. Correct or not?
Betul.
Betul So selalu kita mesti mau tengok balik, kita mesti mau follow up kita punya apa tu
Resolution.
resolution. So even though kalau kata satu hari mungkin lepas you follow up dengan klien, kata dia sudah sign back, but at the end of the day dia cancel the loan itu. Tapi anyhow you pun ada follow up dengan dia, at least you ada satu dokumen kata sepatutnya you ada satu loan, ada satu credit facility, hire purchase facility dengan sesiapa. Adakah itu berlaku? Dan kalau klien kata, oh itu at the end of the day kita sudah tak jadilah, apalah inilah itulah, itu tak apa. Tapi at least you know. Then we do our best to declare all the charges from the company to the public. Kau faham So after incorporation, semua sudah siap. All the approval from SSM has been granted. So apa biasa ya orang buat? Sudah habis cerita.
Lepas
Dia tak ada
Michael
bayar. Dia tak ada bayar kepada company kah?
apa?
Dia tak ada bayar.
Ada, dia akan bayar
Ada bayar. Kalau tak ada gaji tak ada nanti.
And then,
Biasa apa mereka buat?
lepas tu kita akan appoint first COSEC.
First COSEC. Tapi first COSEC you sudah appointed dan masa buat incorporation.
Untuk yang
Betul
kat dalam micro ID punya.
Oh, so appointment of company secretary it come after incorporation lah.
Betul.
Oh, nasib baik you tahu Kita you cakap masuk incorporation sudah ada Okay. Bagus. So from this topic so I think your sedikit sebanyak you orang sudah belajar apa duty company secretary, who is auditors, and then what are the responsibility and the duty of the directors, and then about the shares, about the dividends, all this kind of thing, register office, and then the platform of Micro ID 2016. So all this kind of thing, you all have learned more or less on this. So after this, I will send this slide to the person who won. So you may write us this requirement to get this slide. But of course, you must after the feedback form. So later I will send you all the feedback form. To write. So what is the presentation of myself? See whether this presentation is good. It's good for you to understand everything. Then you tulis okay. It's very good from Mr. Ho. Then I only send you the slide lah. Boleh kah?
Boleh.
Kalau you cakap saya tak bagus pun tak apa Kena honest. Kalau tak baik, cakap tak baik. Nanti saya akan betulkan in future. Tapi slide saya akan bagi juga. Don't worry So, from here, let me see Okay, the feedback form later I will send to you all. And then So our next lesson will be on the 10th of March 2025, next Monday. Yara masih ada ke masa tu? Ataupun boleh ajak lagi kawan boleh masuk? The title of beneficial ownership, the formation of company. I think the formation of company, Yorang sudah ada more experience, got experience on this already. So we have enhanced, we go further. Tengok apa yang terkurang, apa yang mungkin for difficult punya cases lah. Let's say for the example, overseas company become the shareholders, the sole shareholders for this new company incorporated. So what should you do? What are the information that you should gather from the client? And dividend, how to calculate the dividend, how to declare the dividend. When we do the dividend, shall the company mesti mau ada apa-apa cara lagi untuk menyatakan mereka ada capacity to declare the dividend. Beneficial ownership, apa itu beneficial ownership? So next Monday, 10th of March 2025, same place at 514 Jalan Kenanga 2915 Indapura Kulai. Can I see you next week?
Boleh.
Boleh ya? Okay. Then we see you next lesson. Thank you very much.
Thank you, Mr. Ho.
Thank you, Mr. Ho.
Thank you. Bye-bye.